Well, why don't we go ahead and begin with our second panel. We'll try to stay on time today. We started off with looking at litigation outside of the Article III courts, or according to Ken, in conjunction with the Article III courts, and we're moving squarely now to the Article III judiciary with a focus on multi-district litigation. And as Judge Sirica mentioned this morning, multi-district proceedings are now comprising an increasingly large number of the civil case docket. So if you look at sheer numbers, it's about 35%. But if you take out Social Security cases and prisoners litigation, you're actually looking at more like 45.6%. And then if you look at the number of cases that are aggregated within a single proceeding, it actually escalates the number of products liability cases to, I think, around 92%. So we have with us an excellent panel, excellent group of moderators and panelists, and I will turn things over to Judge Rosenthal.
Thank you very much. This is the easiest job a moderator ever had because this group is quite a reliable source of comments, suggestions, and gadfly-like interruptions. And I encourage and welcome us, all of you, to provide those and continue in the format that Judge Hellerstein so ably demonstrated. So we're going to start with the perfect segue that Deepak's last presentation presented, which is back to the MDL, back to court. Welcome. And we're going to shift from outside to inside the courts and look at the kinds of problems that within the MDL reliably make life challenging for the judges who are tasked with presiding over MDLs and with presiding over what happens at the end of the MDL. And questions about the legitimacy to the MDL process and results that can occur because of the challenges that the panel is going to discuss. We're going to start with Judge Vance, who is the current, not only an experienced judge of many years from the Eastern District of Louisiana, otherwise known as the World Center of Mass Tort Litigation, and she has presided over her fair share and experienced her fair share of the natural disasters that gave rise to some of those storied MDLs. But she is now currently the head of the MDL panel. So Judge Vance has a wealth of experience to share with us and can present us with the most accurate and thorough description of what the MDL looks like today. What are the demographics of the cases that the federal courts are dealing with, and when did it change, why did it change, and how did this affect the issues that we're grappling with here? Judge Vance?
Thank you, Lee. And thank you very much for having me here today. Well, in 1968, Congress passed Section 1407 of Title 28, which started multi-district litigation. And since then, we've seen increasing resort to the MDL process by claimants who want to aggregate claims in a single forum. This is reflected both in the increase in the number of motions that the panel has received and in the number of pending MDLs, particularly over the last 25 years. There were twice as many motions before the panel in 2015 as there were in 1990, and there were more than twice as many pending MDLs at the end of these years, 247 compared to 99. As has been mentioned, the portion of the federal civil docket that's concentrated in MDLs has trended upward over this period, and at the end of 2015, 38% of the pending federal caseload consisted of MDL cases. But I have to note that this is just a snapshot of the pending federal docket, and it reflects what is accumulated over time. It does not mean that 38% of the new cases filed in federal courts go into MDLs. In 2015, that was 13%, and the average since 2004 is about 12%. Currently, there are 263 MDLs in 58 districts pending before 206 federal judges. By subject matter, the largest categories of MDLs are products liability MDLs, followed by antitrust MDLs, sales and marketing practices MDLs, securities, and intellectual property MDLs. 3/4 of these MDLs involve class actions, and 81% have 100 or fewer cases. But most significantly for the purposes of my remarks today, 21 mass tort MDLs, or 7% of the MDL universe, accounted for about 90% of the cases pending in all MDLs and represented 35% of the pending federal caseload in 2015. And by mass tort MDLs, I'm using this as a shorthand for products liability and common disaster MDLs with more than 1,000 cases pending in the docket. These MDLs contain individual personal injury cases in which the plaintiffs have their own lawyers, although they are sometimes combined with class actions for economic loss. I'd like to focus on the impetus for this growth in mass tort activity and its impact on the MDL process. This growth in mass tort MDLs took off in the first decade of this century. Until 2003, there were relatively few mass tort MDLs. From 1968 through 2003, there were never more than 4 mass tort MDLs pending in any one year, and the number did not reach 4 until the late 1990s. After 2004, the number of pending mass tort MDLs increased almost uninterruptedly every year from 7 in 2004 to 21 in 2015. This increase parallels an increase in the number of motions to create products liability MDLs coming before the panel. From 1968 to 2003, the average number of products liability motions per year was 3. Since 2004, the average is 15, a 5-fold increase. Today, a majority of these mass tort cases are concentrated in 7 MDLs involving pelvic mesh implant devices that are pending before Judge Joseph Goodwin in West Virginia. There are 75,000 of these cases, which make up slightly more than half of all MDL actions and 1/5 of the pending federal docket. This is the largest mass tort phenomenon since asbestos, which dominated the MDL universe until recent years. These mass tort filings are driven by a number of familiar factors. In 1977, the Supreme Court legalized lawyer advertising. Since then, plaintiffs' lawyers have developed massive advertising campaigns that are increasingly targeted to potential plaintiffs. The plaintiffs' bar has also become increasingly sophisticated in its ability to finance large-scale litigation, including by resort to third-party financing. Further, the cost of litigating individual cases, especially the retention of expensive, sophisticated experts, makes aggregation and the sharing of expenses most attractive. Products are mass-produced, sold nationally, and distributed to millions of consumers. This exponentially increases the harms that a single instance of negligence can cause. Further, we've seen the rise of direct-to-consumer marketing and uniform nationwide marketing campaigns. This has led to more potential plaintiffs and to efficiencies in litigating failure to warn claims in a single forum. Scientific developments have also contributed to this trend, and the publicity surrounding government investigations, product recalls, drug label changes, all of these have also drive large-scale litigation. Legal developments, some of which we talked about this morning, have also contributed to this trend. The impact of AmChem, which disapproved of asbestos personal injury settlement classes under Rule 23, has worked its way through the system, and added to that, the Class Action Fairness Act of 2005 made access to state court class certification much more difficult in the mass torts context. Thus, MDL centralization has become one of the few options left for parties who seek aggregation of mass tort personal injury claims in a single forum. Of the 21 mass tort MDLs, 2 are mass disaster cases, the Deepwater Horizon oil spill litigation and the DuPont C8 litigation. The DuPont case involves contaminated drinking water allegedly caused by a single industrial plant. The other 19 mass tort MDLs are products liability MDLs involving widely used products, usually prescription drugs or medical devices. 2/3 of these mass tort MDLs have settlements in various stages of completion involving most or a substantial number of the cases. And these settlements occurred after significant case development in terms of fact and expert discovery and in some cases bellwether trials. The docket statistics do not reflect the effect of these settlements because settlement administration is required before the individual cases can be dismissed. In the other mass tort MDLs, judges have appointed counsel, issued numerous rulings on discovery disputes, motions to dismiss, and summary judgment motions, and have scheduled bellwether trials or initiated the bellwether process. Handling these mass tort MDLs is an extremely demanding assignment for an MDL judge. They must manage these cases within the framework of Section 1407, the Federal Rules of Civil Procedure, their inherent authority to manage their dockets, and applicable decisional law. But this type of litigation gives rise to particular challenges that stem from the sheer volume of the cases and the presence of hundreds of lawyers representing thousands of clients in separate cases. These cases require a constant balancing act to advance the goals of efficiency without jeopardizing the fairness to individual parties. This problem is obviously inherent in aggregate litigation, where it is impossible for every plaintiff's lawyer to run his or her own case and for the defendants to focus on each plaintiff one at a time. The court must set priorities and establish a structure in which essential facts can be discovered and issues resolved, or the result is not fairness and efficiency, but chaos. MDL mass torts pose particular problems in 3 areas: in the selection of conflict-free leadership counsel and in determining an equitable method of compensating them, in accommodating the needs of plaintiffs for common liability discovery and the needs of defendants to ferret out meritless claims, and in the area of aggregate settlements. This is true because of the absence of the procedural protections and closure mechanisms available under Rule 23, and the court does not have express authority to review and approve aggregate settlements that are reached in mass tort MDLs, and I'm sure we'll hear more about these issues later on in the panel.
Thank you, Judge Vance. So the MDL panel is tasked with traffic cop. You send the cases to where the judge is who's going to preside over them. And you've described this judge as some kind of magical tightrope walker. There's this great movie about the guy who walks between the towers at the World Trade Center long, long ago. That's the mental picture I have. It's truly a combination of a tightrope walker and an Uber administrator. As you look
and a shrink.
And a shrink, that's exactly right, and a banker. As you look over the ranks of the federal judiciary, how do you figure out where these cases ought to go, keeping in mind as well the kinds of choice of law consequences that may result from whichever jurisdiction you choose?
Well, first of all, let me disabuse you that we do not consider choice of law consequences. We do not consider what law is going to govern in what circuit.
That's the other thing the judge has to do.
Yeah, the judge
Right.
has to do this, and so we
So he
don't.
better be a really good judge
Right.
on top of everything else.
So we don't decide based on circuit law where we're going to send a case. Our decision is based on the convenience of the parties and the witnesses, and to try to find a forum that is a convenient place to litigate and also has a judge who is willing and able to handle these cases. We typically will send mass tort MDL cases to a judge who has previous MDL experience. We think that's really mission critical in taking on an assignment like this. But it's a judgment call by 7 experienced judges who know their fellow members of the federal judiciary pretty well, and it's basically a discretionary call by us on where we think it makes sense and who we think is the best judge to handle the case.
Comments, questions? How are they doing? The MDL still a black hole, or is it better?
Yeah,
Alan?
in terms of, oh, I'm sorry.
I'm sorry, and then
I have
to you, Judge.
one short question. Are most of the motions coming from the plaintiff side or the defense side, and has that changed over the years?
We see motions from both the plaintiffs and defendants. We have seen, of the 21 mass tort MDLs, most were either by the plaintiffs and defendants, or one side did not object. There were 5 cases in which the defendants did object to the formation of the MDL and argued, build it and they will come. And the panel has, if that's the only argument against centralization, and we find that there are common issues that can benefit from centralized proceedings, we will tell the defendants that you should take the build it, they will come problem to the transferee judge and find ways to deal with that issue within the context of the MDL.
Yeah.
Judge Robreno.
Judge Vance, in terms of the black hole MDLs, of which asbestos was perhaps the paradigmatic example, has any thought been given, and what are the pros and cons of certifying and consolidating for a certain period of time? For example, 5 years with a presumption of recertification, but it would give an opportunity to review the progress of that particular case and give the parties perhaps what the world looked like 5 years ago is not what it looks like today. Certainly that has been the case in asbestos.
You mean something like a sunset?
But there doesn't seem to be a mechanism by which you could revisit that issue.
Is that something like a sunset provision?
Yeah, but with a presumption of certification. Yeah.
Well, one obvious drawback with a termination provision is that it invites the parties to game the termination provision and to hold out and to play games as you get up to the deadline. So I think that's one potential drawback. Some judges have imposed on themselves a target date for completion of the MDL, but there are so many unforeseen circumstances that can happen in these cases. Some of them will render a decision that goes up on appeal. The circuit will reverse, send it back down, start all over again. So, I mean, there really are contingencies that you can't foresee in this type of litigation. I would also suggest that we don't have the black hole. I think the black hole is a stereotype that we're not seeing anymore, and that of these 21 mass tort MDLs, of the ones that are pending over 2 years, 75% of those are in advanced settlement negotiations and have advanced settlement agreements. And we have 2 of the 21 MDLs look like they're going to go away after adverse Daubert rulings on causation issues. So I think that a black hole is not an accurate description of the MDL process today.
Rick.
As I recall, during the first 5 years or so after the statute was adopted, the panel then supposedly took an ongoing interest in what happened with the cases after transfer. My sense is that it is not happening now, and Judge Robreno's suggestion is perhaps a way of inviting something like that. How would you feel about being invited by the lawyers to second guess what the transferee judge is doing with the case that the lawyer doesn't like?
Well, not very well. We do get, lawyers will sometimes come to us to ask for a remand from the MDL that, to get out of the MDL. But I have to point out that there are 124,000 cases in these 21 mass tort MDLs, and we've gotten a grand total of 7 remand motions of parties who wanted to exit the MDL. So I don't think we've seen a lot of people who want out. But I think that the panel does stay on top of these cases. We monitor and receive reports from the transferee judges every year on the status of the cases, and we keep lots of statistics on how many cases how the cases are proceeding, which types of developments are happening, and and if there looks like there's a problem somewhere, we'll make inquiries. But we really have no statutory authority to do any type of oversight of what an individual judge does in an MDL.
Bob.
Yeah, I suppose my question is this. Do you consider, and if you do, how do you consider any individual plaintiff or individual litigant interests in control of their own suits?
We consider that because when we centralize MDLs, if it looks like to us that a case could be handled through voluntary cooperation among the lawyers and that an MDL is not necessary, we have said in our opinions that the MDL process is a last resort. And we have tried not to form MDLs if we don't think that they're necessary to achieve the purposes of the statute, where you can achieve fairness and efficiency. I mean, the two is convenience of the parties and witnesses and just and efficient management of the action. I mean, it has to secure efficiency, fairness, and justice. It's not just efficiency.
Right. No, I think. Can you be at all specific about what sorts of things you look for that are relevant to, if in fact you look for these, that are relevant to a concern about individual plaintiffs controlling their own suits? I mean, I'm not just talking about fairness, right? Fairness can be outcome-based, it can be process-based, there's lots of understandings of fairness. What I'm interested in specifically, if you can give me, is that if you give me an example of a kind of MDL transfer or potential transfer that was not granted because you said to yourself, for example, this looks like a bunch of plaintiffs that ought to actually be able to control their own suits in a meaningful way.
Well, because there weren't a sufficient number of cases to warrant MDL proceedings. The cases, there were individualized issues that seemed to warrant separate management. Some of the cases were farther progressed and were close to trial, and we decided not to disrupt ongoing proceedings where the parties had made sufficient progress and they looked like they were about to receive resolution, or where there had been actual litigation to conclusion of a number of cases, and it looked like the cases were processing just fine without MDL centralization.
I think that Judge Vance has laid the table nicely, and it's a big table, to move to John Beisner's presentation. And in that context, John, I want to actually pose an introductory question.
Sure.
One of the issues that has recently been raised is whether the MDL process would be improved by or not, or detracted from by writing more specific procedure rules to govern and institutionalize, make more consistent and predictable some of the ways in which the MDL cases are conducted. And that in turn raises the subsidiary question of whether a specialized set of rules would be required for the mass tort cases that dominate a lot of the discussion, and for good reason, because they take up most of the space in the room. So John is going to specifically look at the difficulties for defendants of testing the individual cases, particularly in these mass tort collections. While the plaintiffs are seeking information on the information relevant to common liability, John's really interested in the flaws that the individual claims are going to present and his ability to test those.
And as part of this, I'll get around to answering your
Right. Do we need
question.
different rules to address
Right.
that?
And may suggest some at the end. Really what I wanted to focus on is where do these claims come from? How do they come together? And Judge Vance alluded to, I think, some of this earlier. If you think about most of the mass tort proceedings, they are usually triggered by a well-publicized event or series of events. If you think of some of the recent ones, the GM ignition switch litigation, the publicity about discovery of certain things going on with those vehicles, or in some of the pharmaceutical cases, the Food and Drug Administration making a comment or a manufacturer making a disclosure about a product suddenly triggers a lot of interest in the subject and the filing of claims. And as Judge Vance indicated, most of these claims, I think, come now as a result of advertising of various sorts. Television advertising, most of which you will find on late-night slots on your local stations. Millions of dollars being invested in internet advertising of various sorts. But the market is saturated with advertising for these claims. And one of the problems with it is that, of necessity, this advertising is pretty generalized. And if you analyze the content of many of these ads, it usually boils down to, were you exposed to whatever the subject matter is, whether it's a product or a circumstance, and a statement saying, if so, call us. And there's not a lot else there. I'm not criticizing that. In a 30-second ad or in an internet page, you're not going to be able to explain the lawsuit that might be filed to a layperson, but it's pretty generalized. And as a result, you get a self-selection process that doesn't really match the litigation. You get a lot of people saying, gee, I saw this ad, it said, if I took product X, I might get money. I'll call. I'll find out what this is about. And so you have this self-selection process that is not very strong. You then have whoever is receiving these contacts faced with an onslaught of inquiries from consumers. And I think what we're seeing is that there is not the same type of screening occurring of these claims as you would normally get in individual lawsuits. There are a lot of places you can look for evidence of this, but I would note, for example, that at the end of the Vioxx litigation, we had what I think is in most of these settlements a somewhat unusual gate requirement where to obtain recovery, the claimants in the litigation, and bear in mind these are people who had filed lawsuits, had to step forward with evidence that they had taken Vioxx and that they had suffered either a heart attack or a stroke event. Among those who had filed lawsuits when we got finished, 30% of those who had filed claims could not get through that gate. And it was not a very rigorous requirement. You basically had to come in with a prescription receipt or something that you had gotten the drug someplace, and a medical record said you had a heart attack or a stroke. Substantial money available. Most of them had counsel. So there were a lot of people there with incentives to get these claims filed. And so I think it's an indication that there was not the rigor that you would hope in clearing that to start with. I want to be very clear about this. I don't mean that as a criticism of counsel in these cases. First of all, I would note that a lot of the counsel I deal with are very rigorous in screening those claims. And so I don't mean to be painting with an overly broad brush, but you have this rush to file the claims, and the process just isn't as rigorous as it should be. This is being exacerbated now by another consideration that Judge Vance mentioned, and that is outside funding. A lot of us were suspicious this was going on, but it was confirmed recently with the filing of the lawsuit against the Aiken Mears firm in Texas that I'm sure many of you have read about, which sort of laid bare the role of some funders in financing mass tort litigation. And I think what it indicated, and I'm being too cursory about this, but was the fact that when you have third-party investors, there's not a lot of interest in the merits of individual claims. There's sort of we got a name, we will put it in there, we will attribute a uniform value to all of these claims, and this is what we're going to finance, and this is the level of interest. And so you have this additional layer now of investment coming in, just saying we want a name so we can put a claim forward, and hopefully some money will come back from that. So why is this happening? And I think the main reason for this is that when I file a lawsuit, I am normally going to be reasonably cautious about doing that because very quickly I'm going to be required, if I file in federal court, initial disclosures that at some level justify my claim. I'm going to be facing discovery fairly soon after I file the case, in which I will have to justify the claim. But in an MDL proceeding, the normal practice is effectively to suspend Rule 26 applicability to most claims. You just don't look at them. And so I think that there are some counsel, and I will stress some counsel, who are probably saying, I'll worry about that later. I'm just going to get the claim filed, it's in there, and I'm not going to have to justify this perhaps for years. And that is one of the main concerns that, what's that?
If ever.
If ever. And the hope is never. And I think that's one of the concerns that as defense counsel we have. I'm somewhat optimistic that we are getting our arms around this problem because I think in many MDL proceedings, the judges, I think, are correctly saying, look, we can't do Rule 26 discovery on all these claims. It would be a waste. We don't need that now. But they are increasingly saying we need to have plaintiff fact sheets. We need to have disclosures about these claims that at least give some justification for their existence, for being in the MDL proceeding. To me, the optimal approach is basically to ask counsel to, if you will, show their homework regarding the claim. What is it that I should have looked at before signing the complaint that would justify this under Rule 11? And I think it's pretty simple. It boils down to some documentary confirmation that the person on whose behalf I'm filing this claim was exposed to whatever the controversy is. They took the product, they bought the car, whatever it is, but confirming that there was a connection. Bearing in mind that they've been recruited through a process where nobody's ever sat down with them and said, is this what happened to you? And then I think the second thing is some confirmation that they have experienced the consequence that is at issue in the litigation. If it's alleged that you took a product and you had a heart attack, getting some confirmation, a medical record that you lay on the record as part of this fact sheet process that confirms that they've had that consequence. I think this is important, just to make a final point on this, not only to make sure that there is some verification that the claims there have a reason to be there, but also because I think this is very critical to the court's management of the proceeding. One of the great frustrations that we may hear later in the day is the court confronts decisions, for example, about bellwether trials. Well, unless you have that sort of information about what's the character of these claims, what is the experience that these individual claimants are alleging, whether it's driving their car or an experience after taking the product, you don't know what these bellwether trials ought to look like. And so having that information, having some statistical information about the body of claims, I think is critical. The other part is looking ahead in the case. I think a great frustration as a defense counsel is that when your client says to you, it's time to resolve this case, it is astounding to me that when you go to some, and again, I stress some plaintiff's counsel, and say, I'm here, I would like to pay you some money to resolve this, it takes months for them to figure out what their inventory is, because they've never been required to go through this process to confirm what the claims are, what the quality of the claims are, to provide the sort of information that I, as a defense counsel, am going to need in order to assess the claim. And so it's not just an interest on the defense side. I think that going through this definitional process on the plaintiff side is also critical to the overall management of the proceeding.
Great, thank you. Judge Vance, did you want to say something in response?
I'd just like to echo what John said and to point out that in all 21 of the pending mass torts today, the judges use a fact sheet process that some with more rigor than others, and that in about a third of the cases, the judges have entertained motions to dismiss cases for failure to come forward with this basic information, and the information usually is proof of use of the product and proof of injury by way of medical records. It works better when the judge is involved in the fact sheet process so that they capture meaningful information and that actual records are produced. And the fact sheets can be used if the parties are required to analyze them and the court captures that information. It can be used to structure discovery, to focus on specific issues, and in the selection of the bellwether cases for trial to figure out which cases are truly representative of the census. So I think that this is a move in the direction that, and these failing to file these things can result in dismissal. One other point on the advertising, on the, the third-party financing, and that's something that's just coming on to, I know it's been around for a while, but judges are the last to know, that's just coming on to the radar screen of the judiciary, particularly in these mass tort cases, and we're just only figuring out now what we need to know about these arrangements, how they're structured, and what they might mean for the litigation. I mean, some people might argue that a third-party financier has a due diligence, does due diligence, and won't subsidize meritless claims, or that they could be an effective monitor of how the plaintiff's lawyers perform. Granted, the Aiken-Mears case in Texas seems to go the other way on that, but there may be cases in either category, and judges are now taking a look at this and trying to figure out what we need to know and what, if anything, we should do about this. But we are concerned about compromising the compromises of the attorney's independent judgment if the third-party financier has control over strategy decisions and over settlements, or that this financing creates incentives that create conflicts between the lawyer's interests and the interests of the people he represents.
There's compelling information about how the parties are financing claims at the outset is something that we are not used to doing as judges. Sam, you had a point you wanted to make, and then...
Yeah, John, I wanted a sense of whether you think this problem is changing over time or getting better over time, following the points that Judge Vance made. Right. I think that lawyers respond to incentives, and there were three difficulties in the incentive structure in the MDL process. One was that the selection of the PSC was too often dependent on how many cases one had, which made the plaintiff's bar highly dependent upon the referral lawyers to pump up their volume in order to go into the MDL process and say, I have 10,000 claims. And the point was to get them quickly, and there was no incentive for screening at that point. The second misincentive, in my view, was that defendants, when they realized that the time had come to settle, wanted global peace for the reasons that Judge Sirica mentioned this morning, and so they said, okay, we don't care, we'll pay small amounts on all claims and bigger amounts on big claims, and so that, again, no incentive to screen there. And you and I were both involved in the Vioxx case, and one of the hard, figure out if you've got the guts to do this questions that we had to confront there was Merck willing to take the continued litigation of the 30% that weren't, or whatever it turned out to be, that wasn't going to pass through the gates. And I think that that was a big moment in the mass harm litigation when Merck said, we'll take the ongoing hit and of continued litigation, but we will pay only on the meritorious side. And the third thing is that the judiciary, I think, was slow on, you want to call it lone pine, you want to call it plaintiff fact sheet, but as Judge Vance said, that seems yesterday's news, because from what I see, from when I go speak to the MDL judges and ask what you do in these cases, this is playbook first page, which is tell us what's in my case now. So the question is whether all of these have started to move in a way that relieves some of the concerns you've articulated.
Judge Vance, did you want to speak to that?
No, I think it was directed to John.
Well,
Go ahead. Go ahead.
Happy to defer, but I think the target has changed. I think some things that you've alluded to have gotten better, but the phenomenon that worries me is the following, that I think you were right. There was a point where I want to be lead counsel in the MDL, let me load up on the cases. And I think that has diminished significantly. But the problem that we have now is that there are a substantial number of counsel who have no interest in being lead counsel, who in fact never show up in the courtroom in the MDL proceedings. And if you look in some of these cases, the firms, the counsel who have the most claims are totally inactive. They're just sitting there filing the claims, waiting for a settlement to occur. And for them, this, I think that has moved the wrong direction. So sort of the issues here, I think, have changed. And if you look at the counsel who are involved in funding, getting money from the funders, buying and selling claims, they're often in the back seat of the back of the courtroom if they're there at all. So I think in that sense, this problem has not solved. I also think that largely as a result of that, the sort of settlement that we did in Vioxx, where we did say you're going to have to show you belonged here before you get paid any money, are much harder to do because often the folks with the largest number of claims who aren't in the courtroom are not going to, they're just out front not going to participate in that because their business model is, I don't want you looking at my individual claims. I want to sell you the whole bucket as is. And so they're not going to participate in that. And so now when you go to settle these, they're much more prone, I think, again, toward inventory settlements with the firms or with groups of firms. And it is, I think, much more difficult for defendants to deal with. And I think it's the reason why some of these proceedings have been around for quite a while. So, yes, Sam, some of the things you referenced, I think, are improving, but I think they're being, I won't say outweighed, but balanced in some respect by that. I also just wanted to mention as well, I think another issue is, fundamental resistance to these sorts of inquiries still there. There was a Washington Post article a week ago of an MDL proceeding I was involved in where I was accused of intimidating plaintiffs by insisting they respond to fact sheets. They're not going to participate, and my response was, well, when you file a lawsuit, you got to do some things. But, that's the sort of response that you're getting in some circumstances from some counsel on these issues.
Bill, and then Eldon and Alvin, and Sheila, can I get you and, I can't read that far, thank you, Adam, to defer until after we hear from Bill? Great. Bill.
John started with the question of
Bill Rubenstein.
where do the cases for the MDL come from. I've got a state court docket in our complex courts in LA, and I overlap with Judge Goodwin's transvaginal mesh. I've got thousands and thousands of cases. Some, but not all, the parties say they're going to settle. I've got a different overlap with Judge Battaglia's MDL in San Diego, where we both made a merits ruling recently that'll go up to the Ninth Circuit and the State Court of Appeal. We'll wait with curiosity to see if the appellate courts agree with Judge Battaglia and I, because we did agree. And I've got another big pile of cases that overlap with a pile of cases in state court in Philadelphia where nobody's making an MDL, best as I can tell. Obviously, the future of aggregate litigation seems like it's going to include a lot of cases proceeding in state courts, whether it's in Philadelphia or Atlantic City or LA or whatever, which is something that at least the academics and others should bear in mind. I'm sure the practicing lawyers know it because it's where they go to court when they deal with the cases, but it's not peculiarly monopolized by the MDL. I guess question to Judge Vance, do you give any direction to the MDL judges to worry about what's going on in big piles of state court proceedings? And a different question to John, when do your clients remove and when do they decide they like to stay in state court? But two different questions.
The answer to your question is absolutely, and I think that, Judge Fallon is here. He's one of the pioneers on how to coordinate federal and state MDLs. In all of these big MDLs that I've been talking about this morning, there are pending state court cases, some of which are coordinated in proceedings like the ones you're referring to. And I think the judges have started to appoint a state court liaison to contact the state court judges personally and ask them to participate in science days, in joint Daubert-Frye hearings, and to as much as possible coordinate schedules so you don't see the duplicative discovery and the competing schedules from the two separate fora. But absolutely, that is on the radar screen, and I think Judge Fallon could probably speak to that better than I can.
And is there a process for codifying these good practices into rules that is being done in ways that are formalized or should be?
I think that we've developed and we've talked about series of best practices, but I really don't think that this type of litigation is conducive to a specific set of rules because the cases are so different, and the judges need the flexibility to experiment and to innovate. And some of these cases now, there weren't things such as bellwether trials until maybe Vioxx. And now bellwether trials are sort of the model. There may be a new model tomorrow, and I think that if we saddle the judges with rules instead of best practices, that I don't think it would. No, the judges wouldn't like it in terms of their ability to manage these cases. The cases are governed by the federal rules of civil procedure. There are routes, if the parties don't like it, to seek mandamus or to appeal dispositive decisions. I know in the BP oil spill case there were 44 appeals. So I do think that that rules would. We're not ready for rules yet. I think these cases are evolving in the way that the judges are managing them, and that we should proceed the way we're doing with best practices in mind so that we can incorporate what works and discard what doesn't.
So Eldon, let's take your question, and then, if you don't mind, Alvin, if we can defer yours until after Professor Rubenstein speaks to us, I hope it'll fit there because all of these topics are connected. Eldon.
Just some comments on the fact sheets. That's an evolving situation. With fact sheets now, what we're doing is taking them online. And one of the first things the transferee judge is doing is trying to get some understanding of the issues involved in the case as quickly as possible, and meeting with the outside providers, basically an administrator who's appointed to coordinate the case and design a fact sheet that is able to be used throughout the litigation. The initial part of the fact sheet is to determine whether or not the person's taken the drug or used the product. I think the transferee judge is generally involved in that process, or should be, and polices the situation. And so after a couple of weeks or a month of jawboning it and telling people to file it and do it, then you begin setting rules to show cause why the case should not be dismissed unless fact sheets are filed. It's helpful to do them online because you then can search them, and you can then try to categorize the cases. I'm dealing with Xarelto now, and we've gotten to the point where the fact sheets are in for about 98% of the cases, and I'm able to, at this point, determine the type of issues that are in that case. And so I know up 25% are over 50, 20% are women, 15% are so-and-so. And with that information, you're then able to design what we call a discovery pool that mimics that census of the litigation. And it's you get the plaintiffs to select some cases, the defendants to select some cases, but random selection in those various categories. And then from that discovery pool, the parties then discover the cases and drill down, and from that you can then get an accurate or a better selection for your bellwether cases to participate. I think that's been helpful. With regard to state liaison and state coordination, I think what transferee judges generally are doing now is to immediately contact all of the state judges and talk with the state judges and coordinate the litigation, appoint a state liaison committee, give the state judges an opportunity to fill that committee, to decide who goes on that committee, and appoint that individual to participate in the discussions which go on every month in most transferee courts to keep the litigation moving and to keep the state court and the federal courts coordinated. I think by and large it's been working, but I think the history of this type of litigation is such that, as I said before, we're almost at the point now where we're in the teenage years. We've been dealing with this, really this bubble of litigation for about 10 years now, maybe 15 years. And we're just beginning now to recognize some of the aspects and some of the problems. And before any hard and fast rules are set, I think the stage is now where there's been some uniformity of practice and some suggestions as to the best practices. And we're trying and moving in various directions, but eventually we're going to get to the point where I think the rules then can solidify all of the movement that has been made. But we may not be there yet. I'm not quite sure we are. I see things changing. I've evolved, and I've done a couple of these cases now, and I've evolved from Propulsor to Vioxx to now, Xarelto, through Chinese drywall and a couple of others. And I see it changing as I'm going along.
And we do prolong adolescence. Speaking of prolonged, Eldon,
no,
that was a gentle.
Yeah. Well, that's all I had to say. Thank you.
All right. All right, so we've heard the Book of Eldon, and we're going to set it to music and take it on the road, and it's going to be a smash hit and take us to adulthood. Bill, help us get there.
Well, let me start by saying I strongly believe that mass events ought to be resolved by mass litigation. I've written that the shape of litigation ought to reflect the shape of the social activities which give rise to it, so that the mass marketing of a pharmaceutical product, for example, properly engenders mass litigation when the product allegedly malfunctions. That said, we're left the task of finding a legitimate means of adjudicating cases in an aggregated manner, and I fairly strongly believe that the current MDL means of adjudicating mass cases in the aggregate suffers a significant legitimacy problem. And I want to try to demonstrate that by talking about and following a single case through an MDL to resolution, then posing a hypothetical question about that case and making 3 points. For purposes of time, I'm going to cut the single case. We never talk about single cases at mass conferences, down to a single paragraph and then get to my hypothetical question. So here's a real case. A woman in Douglas County, Kansas, pregnant woman worried about postpartum depression she had suffered during prior pregnancies, took a drug called Zoloft, an antidepressant drug, during her pregnancy. She gave birth to a child. The child was diagnosed with birth defects. Some years later, she came to believe that these defects were related to her taking of Zoloft during her pregnancy. She retained an attorney in Kansas. The attorney in Kansas filed a case on her behalf in Kansas State Court, suing Pfizer, the manufacturer of Zoloft, which is a Delaware corporation with its principal place of business here in New York. Pfizer removed the case to federal court in Kansas, and the case was then sent to an MDL in Philadelphia, which had been pending for several years before that. So this became a tag-along individual action in an MDL in Philadelphia. At the outset of the MDL in 2012, Judge Roof, who was handling it, had appointed a plaintiff steering committee. The plaintiff steering committee and the defendants had engaged in discovery for several years. The defendants then moved to exclude the testimony of several of the plaintiff's expert witnesses who aimed to demonstrate a causal link between Zoloft and heart defects. And following their success with these motions, the defendants moved for summary judgment on the grounds that the plaintiffs could not prove causation in any of the underlying cases. Just this past week, a week ago today, on April 5th, Judge Roof granted the defendant's summary judgment motion, which in one fell swoop disposed of 311 cases via dismissal. They're all gone, including the case from Kansas that I just described. Here's my hypothetical question. Assume that the Kansas lawyer who filed the Kansas case tomorrow walked back into Kansas court and simply refiled the same case all over again. Sheila, you represented the defendants in this case, correct?
Absolutely.
Yeah.
I'm ready to respond.
Hopefully I haven't yet to give you anything to respond to.
I take great pride in the fact that this may be the first MDL that was totally dismissed on the merits.
Good. Well, sit tight. If the lawyer were to walk back into Kansas court and refile the same case, I assume you would move to dismiss it on the grounds that it was precluded by the decision of the MDL court. I have no doubt whatsoever that the Kansas court or the federal court to which you would remove it or the MDL court to which you would again transfer it would all say that the case was precluded. But on what basis was the summary judgment motion preclusive of this person's case? We say that she was a party to the MDL proceeding and she's bound accordingly. We tell ourselves that, but it's a bit of a legal fiction. She chose a lawyer and a forum, but her case was not litigated by her lawyer, and it was not litigated in her home state or even her local federal court. And indeed, her case was disposed of by a court that likely lacked personal jurisdiction over her in the normal reach of a federal court in a diversity case. The lawyers who represented her did not know her. Nothing about the facts of her case were part of the decision disposing of it. Nothing about Kansas law was part of the decision disposing of her case. Indeed, the federal court dismissed all of her state law claims at summary judgment without the plaintiff's steering committee or the defendant's lawyer or the court ever saying a single word about the substance of Kansas law. When we say someone was a party to a lawsuit, we generally mean that they controlled the case. Surely this can't be said about this individual from Kansas. A second basis upon which we might justify binding her to the outcome of the MDL order is that she was adequately represented in that proceeding as a class action. But of course, she was not represented in any formal capacity. The court did not certify a class, and given Amchem and Ortiz, it likely could not have done so. What may make us queasy is that there is a federal rule of civil procedure directly on point, Rule 23. That rule more or less explicitly bars aggregate litigation in these circumstances, and yet this is precisely what is occurring in MDLs. A third basis upon which we might justify binding this woman to the outcome of the MDL is that she agreed to be part of that proceeding. This, too, is a thin thread, though perhaps her lawyer's filing of a case 2 years after the formation of the MDL should have warned him that he was hitching her Kansas wagon to that Philadelphia stagecoach. This hypothetical raises these 3 points for me. Number one, I think MDLs have a significant legitimacy problem. The legitimacy problem concerns the binding nature of the process. While the Kansas individual's case, that dismissal of that case is an extreme, we generally assume that every order in an MDL is binding on everyone whose case is transferred into the MDL. The legitimacy problem is not that of repeat players that Beth Burch has written about, or of too high common benefit fees that I've written about, or of ethically questionable coercive settlements that Howard Erickson, Ben Zabursky have written about, or about Roach Motel capture of constituent cases that Sam has so perfectly characterized many MDLs. These are all problems, but they threaten the legitimacy of the MDL primarily because the MDL is binding on constituent cases. Short of such a binding effect, these problems might generate more of a voyeuristic concern along the lines of, hey, look what's going on over there. Boy, I'm glad I'm not part of that proceeding. But the binding nature of the MDL makes all of these problems a legitimacy concern. Point two, the legitimacy problem is deepened by several collateral facts about MDLs. These include the many conflicts that plaintiffs' counsel have in MDLs that make the adequacy rationale for binding the constituent cases particularly problematic. And I'll skip over that for purposes of time. Point three, and I'll conclude with this, I think Congress could achieve many of the same goals and we could do many of the same things we do in an MDL, short of having a binding effect on the constituent cases by moving to a stay procedure rather than a transfer procedure. Specifically, the panel's establishment of an MDL could stay related cases throughout the country. Exemplary cases could be developed and tried within the MDL with no binding effect on the other cases throughout the country, but with the hopes that they would lead to some exemplary resolution, as in the Zoloft case, or a proposed opt-in settlement, as in Vioxx. Once the settlement was proposed and time given for opting in, the panel would lift the stay on the cases around the country that hadn't, and those that wanted to could proceed. The defendant would have the right to present the MDL court's decisions as persuasive on the other cases, but these MDL orders would not be binding, and the constituent cases would have the opportunity to show that they were wrong or inapplicable to the specific case at issue. This would generate more litigation for the defendant, but only in the presence of plaintiffs' counsel who thought there was sufficient reason to invest money in pursuing a different outcome on particular facts or law inapposite from the MDL resolution. I think such a stay procedure would capture the present aim of the MDL at being exemplary or bellwether, while simultaneously enabling MDLs to shed the notion that they are operating as illegitimate quasi-class actions. Without the authority to bind, no such accusation could stick in the same way. I'll leave it at that.
Ricky has given us permission to go a little bit over. If you don't mind having some additional discussion stand between us and lunch. But that's a provocative proposal, and we still have Judge Robreno to hear from. So we have several people already queued, and I know Judge Vance wants to speak. I suspect that Sheila would like to speak, and several other hands. So if you, Judge Hellerstein, if you don't mind.
I'll wait until this afternoon.
Can you? God bless you. Sheila, why don't we start with you since you were already in the queue?
Well, that gives me an opportunity to respond. First of all, your guy from Kansas and every other lawyer had an opportunity to come before the court on an order to show cause to explain why their case was different, or whether they would have had an opportunity to get a different expert who might do something different. So she was represented in that case by her lawyer who could have come forward if he ever wanted to or had anything that was different. Judge Roof is a very thoughtful judge who gave 2 opportunities, not one, did it twice, did Dauber twice, concluded that there was no scientific evidence based on the methodology that these people came forward with. And they would have certainly, your Kansas lady and her lawyer would have certainly wanted to take advantage of any rulings the other way. So it's a two-way street. You're bound by the good things that come for you, and you're bound for the things that aren't. They had a perfect opportunity. If anyone felt differently, if anyone had any other evidence, if anyone wanted to rely on any other evidence, to come forward and do it. They had sufficient time, they had sufficient opportunity. So when you go back, take a look at that order to show cause, see how many lawyers came forward with anything different. 0, because there wasn't anything different. The Plaintiff Steering Committee did the best they could with the science they had, which was not there. So I think you really can't use that example as an example of something that was not properly done. And usually it doesn't come out that way because people settle. Some defendants are getting to the point that they're tired of settling cases that don't have scientific merit. And so you're going to see more of these efforts, and you're going to see more efforts to to force the plaintiffs to show what proofs they have. As you can see, the vast majority of these multi-district cases are drug cases, are device cases, and science is very tricky in those cases. What I really was going to respond to was the fact that there have been changes, many changes, I think. As you said, Judge, everybody learns from everyone else, and I think that the multi-district panel and the education they do of multi-district judges has been very helpful in getting the judges up to speed, learning from each other, and as you said, Judge Fallon, we keep getting a little better at what we're doing, and I think judges understand that they have to know what the plaintiffs are and if they're real, and dismiss the cases that are not real plaintiffs because they never took the drug, they can't prove it in these certainly pharmaceutical MDLs. So I think the panel really and they have done an incredible job in helping educate judges to what's really going on and learning from each other.
And did you want to respond briefly, Judge Vance? And then we had some more questions that I want to be sure we get to.
One point is that non-dispositive rulings in an MDL are not binding in any res judicata or collateral estoppel effect. It's law of the case or reconsideration doctrines which permit a transferee court to reconsider if there's new evidence or error or a miscarriage of justice. And it's only when there's a dispositive ruling in a particular case or the parties agree that a complaint is going to be the operative, joint complaint is going to be the operative complaint to supersede the individual complaints. Those are the only times that the rulings are binding on individual cases in a mass tort MDL. And I would point out that Section 1407 is the source of legitimacy for transferring that case and having a different judge make decisions in that case. It's a statute which confers legitimacy on the process, and the debates on Section 1407 demonstrate that Congress intended for summary judgment to be part of the arsenal of the transferee judge.
So I've got Adam and Bob and Beth, and then we're going to switch to Judge Robreno, and then we will have additional questions. If your question can be deferred, that'd be great. Go ahead, Adam.
I actually have a quick question, I think. I'm trying to get a sense of how often any of you might have explored the concept of a bellwether settlement as opposed to a bellwether trial. This is a procedure that was used by Judge Marnotti in the New Jersey state courts, where rather than using trials to set appropriate values, he had a series of mediations, 20. And the results of the mediations were evenly distributed to the parties. And that led to a global settlement of maybe 5,000 different medical device claims. The idea behind it was that even though there might have been some information loss in terms of an actual value, there was other information gains because the parties didn't hunker down into their respective positions in the course of the mediation. More information was shared, and in his view, that helped lead to such a settlement.
Show of hands, anybody who's dealt with this besides Francis, who I suspected would be there? Just very briefly, if you would.
We've done private trials. We've done summary jury trials. We've done private mediations. All of the above. It's not used very much, but private trials are actually something that would be worthwhile talking about because you can do bellwethers privately and it can set the stage. So the answer is yes.
Some loss of transparency, however. Bob?
Right, so I really appreciate Bill raising this particular issue and the legitimacy problem. I guess I have two questions for him, or two comments perhaps. And one of them is, it strikes me that, and this anticipates a few things I'll say this afternoon, but it strikes me that one has to define what's not legitimate about this. That is to say, one has to define what kind of right, if it's a rights-based sort of argument, the woman you describe ought to have or have in the system. It's a compelling story in some respects, but it seems to me it requires that prior normative determination about what it is she really ought to have. And secondly, I worry about, I think your proposal, which I find intriguing, I do worry about the strategic incentives that it will produce, where in settlement, rather than actually realizing this opportunity, it'll simply be a bargaining chip in getting a bigger settlement.
Yeah, let me just say one thing real quickly. As to Sheila's comment as well, I have absolutely no reason to believe Judge Roof got it wrong. And therefore, I have absolutely no reason to believe the Kansas lawyer would go ahead in Kansas and would have any success whatsoever if he did. Your whole point, though, where we differ, I think, and this comes to Bob's point, is that you see the order to show cause saying to the lawyer from Kansas, come in and add anything. It actually said, if you have anything non-duplicative to add to what the plaintiff steering committee has already done, you're allowed to add that. You see that as being a sufficient due process to bind her to the outcome of that case. And Bob, I don't have an absolute answer to your question, but I think there's a continuum between the full right to litigate your own case and what we have in the MDL, which may be an invitation to add something if you have anything. And the latter seems to me a slim read, but I don't know exactly where on the continuum to draw the line.
So Beth has very kindly deferred, and we're going to move to Judge Robreno to end on a very optimistic note before lunch, and that is how it's possible for judges to actually bring it home after years of failed efforts to do just that, and to extrapolate from that the kinds of cases in which it is possible to achieve a very broad settlement, including of related state court litigation, and cases in which it is not.
Well, I have been the MDL 75 judge since 2008, and I was uniquely suited for this task since I knew nothing about it, had never tried a case, and knew nothing about asbestos. So that's why I was elected for this job.
So you were qualified.
The case, as you know, the asbestos litigation has been around since 1991 when the panel, after 4 efforts at consolidation, ultimately decided to consolidate the cases in the Eastern District of Pennsylvania. For the first 15 years of the case, there was an effort to try to achieve a universal global solution. First, through the class action mechanism, and a settlement class was certified by the Eastern District of Pennsylvania, and it included thousands of claimants, including future claimants. That effort crashed on the shoals of the ANCAM decision by the United States Supreme Court. After that, there was an effort to try to find a legislative solution, and Congress made several attempts of putting together an administrative settlement mechanism akin to black lung or workers' compensation. There was not able to find a consensus among the stakeholders, and ultimately, around 2006, those efforts ceased. So there was a need for a new model, and there is where what I have called one plaintiff, one claim came about. And the effort of one plaintiff, one claim was to deconsolidate, in a sense, the mass of asbestos cases that have been placed together and treat each case as if it was an individual case of one plaintiff against one defendant. Now, at the same time that the global efforts had failed, there were several developments, external developments, that were affecting the litigation. And that was one of the reasons I raised the earlier point that the dynamics of the world don't necessarily stop because there is a lawsuit pending. For example, there was tort reform. Looked very differently in 1991 than it looked in 2008 after a number of states had passed legislation that made it more difficult for plaintiffs to prove their cases. The original defendants, who were manufacturers or distributors of asbestos, had almost all gone into bankruptcy, and the new set of defendants, what we call peripheral defendants, were defendants that neither manufactured nor distributed asbestos, but had used asbestos in products that they had placed in the market. We had the developments in the silicosis litigation, which some of the same lawyers and some of the same experts had been shown to have committed fraud. And some of that fraud made the judiciary perhaps more skeptical about some of the asbestos claims. And then finally, there was a rise of the trust as a result of the bankruptcy of the manufacturing defendants. A good deal of money was now available as a supplemental, as an alternative source to compensate victims of asbestos exposure. So with that in mind, a system of one plaintiff, one claim was developed, which basically created 5 or 6 fairly simple steps. Number one, all of the cases were severed into single plaintiff cases. We had one case from Mississippi that had several thousand plaintiffs actually in one case. So there was a need to make each case against each defendant a separate case. Number two, as we have discussed at some length, the necessity for a diagnostic or a medical report would be required of each plaintiff as sort of a ticket of admission into the litigation. Discovery request would be handled by magistrate judges on the same day in which that request was made. They were resolved on the telephone on a 24-hour turnaround basis, so that would not interfere with the litigation. There will be a scheduling order for each case individually, so that each lawyer in each case would know specifically how the case needed to advance. At the end of that period, there'd be summary judgment that will be turned around within 90 days, and then a prompt, either a trial date consistent with lexicon, or a remand to the transfer court. So the process worked. The lawyers bought into the process. Plaintiffs' lawyers were favorable to the process to the extent that their stronger cases got priority. Defense lawyers got the opportunity to deal now with the cases that were meritorious cases. And the litigation had progressed over the last 7 years from 182,000 cases to 500 cases. So the question really becomes in this kind of a conference whether this is a sui generis type of litigation, never to be seen again, or whether there are any lessons that can be learned for better or for worse from this last 25 years experience. And I think that we need to be cautious about drawing any lessons from this litigation for a couple of reasons. Number one, by the time that we began the one plaintiff, one claim program, values have been generally established so that there was no need for bellwether cases or cases the like because of the length of litigation in the state court. So most lawyers knew what the value of any particular case was, and that, of course, helped the process of settlement of these claims. Secondly, because it was a mature tort, a general causation was generally established in these cases. That is, diseases that were connected with a particular exposure. So, in most new MDLs, neither the values nor general causation has been established, so in a sense, we're picking up the story here halfway down the road. But there are a few limited lessons that I think may be helpful, if not to treat an entire MDL in accordance with this model, but at least pick up some of those lessons. I think number one, perhaps it's not even a lesson, perhaps we all know now, that it is extremely important to require a ticket of admission into the MDL. That the number one responsibility of a judge who's assigned an MDL is to be sure that each, certainly in a mass tort setting, that particular plaintiff has, in our case, a diagnostic report that showed that there have been exposure and that a medical profession would offer an opinion that that exposure had resulted or had caused a particular illness against a particular defendant. Number two, I think that we need to have a philosophy that is perhaps somewhat contrary to our experience as federal judges. That is, we're the captain of a ship in each of our cases, and we are reluctant to perhaps parse out any responsibility to either magistrate judges or special masters or others. A case of this magnitude requires that the presiding judge offer substantive guidance and, of course, retain the authority to issue substantive rulings. At the same time, administratively, I think it is important that the judge brings on board the necessary resources to ensure that the cases are moving, efficiently and on a timely basis. In connection with that, I call it let the judge be the judge, let the lawyers be the lawyers. The judge has to address issues. He has to issue, for better or for worse, substantive rulings. He has to rule on motions for summary judgment. He has to rule on discovery issues as they arise and set up a context and the dynamics in which the lawyers can then be lawyers and then can they make the decisions involving each individual case. They know their case better. They know their strengths and the weaknesses. In connection with that, also the danger of what I call waiting for Superman or waiting for super judge that is going to resolve the controversy. We're going to stay discovery while we are going to explore some type of a global or universal solution. Well, that may be fine in some cases. It has a certain cost. The cost is that the lawyers and the judge then lose sight of the individual cases, and the individual cases are basically parked to the side while these global solutions are sought and hopefully achieved at the end of that particular road. So I think then the asbestos litigation, which is now pretty much come to an end, there's only about 400 cases a year which are filed in the federal courts, and certainly the local courts are able to handle those cases. may be of limited value in learning some limited lessons. The final point that I would like to make is the necessity to consider the remand process at the end of this entire handling of the cases. That the cases are not the property of the transferring court, that they're there for a particular purpose, and they're there to resolve the pretrial issues. And incidentally, if they can be resolved, that's certainly a benefit to the system. But ultimately, and it helps in the dynamics of the case, and it helps in the focus that the lawyers have, they're going back. They're going back to the transferal court. That thought that the cases will go back to the transferal court is helpful in attempting to move the cases along. So I think that's 25 years in 6 minutes.
That's pretty good. So the good news is that while we are going to move the discussion to lunch and the afternoon, we are not ending the discussion. All four of our panelists have given us good food for thought, and we will translate that into good food, which I'm depending on NYU to provide. You tell me if that is a justifiable risk, and it is. And let's continue this discussion after we thank our panel.